in the Companies Act, it is applicable to the LLP also. Earlier, they had Section 75, read with Rule 37 of the LLP Rules 2009, which was dealing with regard to the striking off. Now, even 248 to 252 relating to the restoration of the name has been brought into LLP. So the legal framework is the same. You make an application to the ROC in Form 24. In the LLP for strike off, you use the form STK 1, STK 2. Here in LLP, you use Form 24 for with the consent of all the partners of the LLP for striking off the name in the from the register. So this is suo moto. If you are not carrying on business for more than 1 year or so, it can make an application in Form 24 to the ROC with the consent of all the partners of the thing. And if the registrar has reasonable cause to believe that the business is not being carried out and in accordance to the provisions of the Act for a period of 2 years or more, the name of LLP can be struck off from the register of the LLP register. You can use it. So here, suo moto action can also be taken by the ROC from the for striking of the names of the LLP. So again, the reason for which you will be taking off the names or striking off the name of the LLP is the same what we have with companies. The company will not be carrying on for a period of 2 years, but operation is not there for 1 year. The LLP can suo moto make an application, and if the ROC feels that the business has not been carried on for a period of 2 years, suo moto, it can strike off the name of the LLP. Before striking off the name of the LLP, the reasonable opportunity of being heard is given to the LLP. So ROC strike off suo moto, that is according to Section 75 of the LLP Act of 2008, read with Rule 37 of LLP Rules 2009, amended from time to time. So suo moto, what is the reason? If the LLP is not carrying on any business or operation for a period of 2 years or more, and the ROC has reasonable cause to believe that, then he can strike off the name. So what is the procedure for strike off of LLP? First, you give a notice to the LLP, that is ROC will give a notice to the LLP. The LLP will reply to the notice. Then the consideration of the representation is made in terms of whether it is suitable to strike off the name or not. Then the publication of the notice is made, and then if anybody has any objection, they will be giving the reply to the notice of the publication, and then the striking of the name will be taken place, and any amount which is there which can be realized will be taken, and dissolution of the LLP happens. That is the last step. So now first and foremost is your service of the notice by the ROC to the LLP. So if it is suo moto or as a reply to the application, the ROC is required to send a notice to LLP and all the partners of the intention to remove the name. So once and also the notice will contain the conditions because of which the name will be removed. LLP, on receipt of the notice, all the partners are to give their representation in relevant document explaining to the ROC why their name should not be removed from the register, and this should be given within 1 month from the date of the notice. Please remember, it is date of the notice what is there, and date of the notice is what we are considering it here. 1 month from the date of notice, your reply should be given. Consideration of the representation. The ROC will consider the representation. If the registrar is not satisfied with the representation, it may proceed to strike off with the name. Not satisfied, if it is satisfied that okay, the LLP is telling why its name should not be struck off, then the LLP's name will not be struck off. If they find that it is not reasonable explanation, so the LLP name will be struck off. You go ahead with the strike off. So notice of the same will be placed on the website of MCA for the information of the public for a period of 1 month, and such public information will be given so as to give the general public an opportunity to make their objections in case there is any. So within a period of 1 month of the date of publication, if if the no objection has been received by the MCA or by the ROC can go ahead with the striking off of the LLP. The expiry of limit of 1 month, and unless the cause to the contrary that LLP has been given an extended time period, no objections are received, then the ROC can proceed for strike off. Then the provision for realization of the amount, in case the striking off has taken place, the name is removed and any discharge of liabilities, obligations has been done. If there is any amount which is due to the LLP, LLP has discharged all its liabilities. If there is any recovery which is required to be done or a refund which is required to be taken, etc. So at such times, what happens? The LLP will have a realization of the amount. So it will discharge all the obligations in whichever way it is, and whatever money is remaining will be divided amongst the remaining partners on the profit sharing ratio, or however they had decided in the agreement what was undertaken when they formed the LLP. That is your partnership agreement. Then the notice of dissolution after the expiry of the time mentioned in the notice of 1 month. So then you will be giving the ROC can strike off the name of the LLP and publish the same in the official gazette. Once this thing is published in the official gazette, the LLP shall stand dissolved. On the publication of this notice, the LLP will stand dissolved. So strike off is, this is with regard to the procedure for strike off of LLP. So what are the different rules with regard to the LLP? Again, we are going to repeat the same one, subject to provision of Section 75 of LLP Act, Rule 37 of LLP rules, and also Sections 248 to 252 of our Companies Act of 1956, 2013. All of these are included for the way of recognizing the strike off of LLP. So the same way what we are going to think is the partners of LLP shall make an application in Form 24 for striking off. Before going in for strike off, there are few conditions. The company, if it is a newly incorporated LLP, it has not carried on its business for the first year, 1 year of operations, or if it is an existing company, it has not carried on any business or operations for a period of 1 year preceding the year in which the strike off is going to be applied for. So in such a case, Form 24 has to be filed. So before that, any pending forms, like we have the annual forms, annual reports, which has to be filed in Form 18, 8 and 11 of the end of financial year is required to be filed by the LLP to carry on the business operations. And any other special law, whatever is there, their sanction also has to be taken. So special law, like if it's an insurance company, it will have IRDA regulated one. So IRDA permission has to be taken. If it is based in any foreign country, FEMA regulation has to be followed. RBI permission has to be sought for. All these things are required to be taken up. Then all the designated partners will execute an affidavit jointly or severally mentioning that in case, along with Form 24, that in case any liabilities or assets, whatever has been stated is true, and in case the company becomes company is unable to pay off the debts later on at a stage, it is coming to the notice that LLP owes somebody or some amount is to be payable, that amount will be taken up by the all the partners together. So acknowledgement of the income tax also has to be given. Then also the initial liability agreement but not filed, if entered into but not filed, along with other details, whatever is there. The affidavit, whatever is going to be signed either severally or jointly by all the partners, even in case that the business has not commenced, you are going to state that the business was not commenced and no liabilities, etc. is there with regard to the LLP. It does not owe any money to anybody. In case later on it comes to the notice that there is any money owed by the LLP, then all the partners will jointly and severally repay the money. So
severally means more than two people.
Which one?
Severally means more than two people.
All. Jointly means all of them together. Severally means everyone compulsorily.
Okay. Right.
It is single, well, like banks, what we do jointly or severally, in the sense two people will be signing it only if there is this whoever has agreed that these are the signatories to the check. If we say this person X and Y, so we will say jointly, singly, jointly, or either or jointly, something like that. Here when we say jointly or severally, jointly means those people who are signatories, they will sign jointly. Severally means all of them.
Okay.
Okay, so that is the condition.
Right.
If there are only two partners, yes, please.
Means in LLP, why there is the severally and the jointly there used, ma'am, actually in the LLP?
Anybody can sign. This is used even in company also.
Okay.
Directors also, either two of the whoever is the signatories, they will sign it, or whoever is whoever all the directors will be signing. So that provision has been given. Though, like, we don't have to, then if one director signs it secretly, others don't know. So the one designated partner signs and the others don't know. So it will be at the awareness for everybody. So that is why they have given this option. So that again will be dependent on your internal agreement also. Here the Act is telling this. So what is the agreement in the partnership agreement, that we have to see. Act is permitting whether you sign single, joint or several, it does not matter. How you have mentioned the same provision in the Act, in your agreement, that is what matters ultimately.
Actually, but the word several doesn't actually, the literal meaning of several is not that, what you are saying. Right, ma'am?
Which one?
The word
severally means all of them.
No, what you said is correct. Severally means all of them. But what I'm asking is, when we use, we say it as several reasons, many reasons.
Yes.
That is different several.
Correct. Here, jointly means those who have been mentioned, they will have to sign it together.
Okay.
Severally means all of them who are there, several people. So here we assume that several means all of them, all the partners, designated partners, not all the members.
Okay.
And again, the chief distinction between LLP and a private limited company is, private limited company maximum 200. LLP does not have a maximum limit with regard to the members, but designated partners, I think 20, something like that.
Okay.
So here, only those people can be signed.
Okay.
What you say is correct. Several is plural. So many of them that way. Several things, what we will think. So here severally means all of them who are there.
Okay.
Yeah. Then that the LLP has no liabilities, and in case indemnifying of any liability, if there are which may arise after the striking off also, even after the striking off of the name from the register, then LLP has not opened any bank account, and if it has opened any bank account, NOC from the bank that the account is closed and no transaction pending. No liability is pending there, and LLP has not filed any income tax where it has carried on any business. Okay, so all of this, then copy of the initial LLP agreement, because this is the crux of the thing. LLP's crux is just like, because all the advantages of partnership are taken up by the LLP, but all the disadvantages of partnership are removed from the LLP. Three main disadvantages of partnership was that it did not have succession, there was no limited liability, and it did not have perpetual, and it did not have separate legal entity. So these three disadvantages have been removed, and all the other advantages of partnership also have been given to LLP. So the partnership agreement, just like how it does in partnership, it is applicable to LLP also, and that is what regulates the way you have articulated partnership agreement for the LLP. So the copy of the detailed application, whatever reasons for the closure, will also be put in here, and also authority to make the application duly signed by all the partners are to sign the application here. And in case of date of cessation of the commercial operations, because we have to calculate 1 year from the date. So generally from when it stopped generating the money, that is the date on which it ceased its operation. Public notice, website of the Ministry of Affairs, for a period of 1 month, we are going to keep a public notice so as to give an opportunity for the general public to put in the notice to raise any objections, if any. Then after the limit of 1 month, unless there is any other thing, no objections have been raised, it can go ahead and strike off. Realization of amount, we have just discussed this, and once the strike off is done, the same thing will be published in the official gazette, and once this notice is published in the official gazette, the LLP stands dissolved from that date. So what are the main liabilities of partners to be continued after the striking off? So whatever may be the case, all the designated partners, we call the DPs, will continue with their liability even after the LLP has been closed, with respect to all the things whatever they were doing with the LLP. With regard to any business affairs of the LLP, all the liability of the partners will be going ahead, will be taken care of, and no provision shall affect the power of the tribunal to wind up the LLP. Order of the tribunal is final. If they feel that the partners may say, oh no, we cannot wind up the LLP, please do not wind up, these are the reasons why we don't want the name to be struck off or anything. If the tribunal is not convinced, it can order for a winding up. Nobody can question the authority of the tribunal until and unless the company appeals to the NCLAT, okay, to the appellate tribunal. So other than that, there is no other way which the authority of the tribunal can be questioned. Then the most important thing is this part of it. This has been an amendment applicable to you. So please remember that you may get a question. Restoration of the name of LLP. So till now, there was no formality as such for the restoration of LLP, name of the LLP once it was struck off. Though a few NCLTs, because whenever there is a strike off of name from the ROC, you can appeal to the NCLT stating that the name has been wrongfully struck off. And the NCLT can restore the name. This is with regard to the company, what we have under section 248. But in this case, restoration of LLP, we did not have any option. But a few of the NCLTs, NCLT Chennai and NCLT Kolkata, these two NCLTs had passed orders based on Companies Act. That was under section 248. They had restored the name of the LLP. So there was a contention as to how you could restore it under a different act when you are bound by LLP. So currently, in recent times, that is February 2022, this act was amended, the LLP Act was amended to apply the provisions of Companies Act. Many sections of the Companies Act are applied on the LLP, and this is one of them, restoration of the name of the LLP. So in such a case, what happens if the name is struck off, even though the LLP is active, but the ROC has wrongfully removed the name either inadvertently or because of incorrect information or whatever may be the case, we are earlier what used to happen is it used to file a writ petition under the Constitution of India for the restoration of the name of the LLP. So this was what was the thing, but now you have section 248, the provisions of section 248 to 252, which is the one for restoration of the LLP, which has become applicable to the LLP now. Okay, so this is with regard to your chapter. And the power of the LLP to bring it to active status from the is maximum is 20 years. Within 20 years of strike off, only the NCLT will have the power to revive the company once it is struck off. This is with regard to your chapter on strike off. Please, when you are studying this subjects, whichever may be your subject, whatever you are doing, module 1, module 2, whichever subject you are doing, whenever you study, this is a tip what I have been suggesting, and it has worked for many of them. It worked for me also. First, go through the guideline answers with regard to that particular subject. Read through it. Don't mug up. Don't get scared. Just go through it. Like, for example, you're reading jurisprudence, JIGL, then you just go through that subject. Read through it once, twice, and then as many, because I think I have shared around all the 5 of them. So you go through all the 5 of them with regard to the questions only from JIGL. Question, answer, question, answer, question, answer. Read through it. And then when you start the study material, first read the glossary and these terminologies and the lesson roundup. Then start with the first part of the lesson, what is here. And then you start with, and then read the questions. Then you start reading your chapter. This will give you an insight into what is required what are the type of questions which are coming in the question paper, what are the answers which are there, which are expected, and you will understand that there are many questions which are not repeated, but the answers are the same. And also, when you're reading the other thing, glossary, define, you will remember the amendments, what has taken place in that act for that particular exam. And you will get an idea of reading it 3 times almost, when you're reading the glossary, when you're reading the guideline answers, and when you're reading the lesson outline. Those terms and those topic headings, etc., will be revised almost 3 times. You will feel a little more familiar when you go through the chapter per se. So it will no longer appear to be foreign. It will no longer appear to be difficult. It will not be scary. So you will be confident when you're going through the topic. Okay, so this is the tip what we have. So starting off with our next chapter, the last chapter, wish I had said this last chapter also. So this is a very important one. You have a full subject. You have, in fact, a specialization also, which you can take in professional paper with regard to your insolvency. And you have a full paper, corporate insolvency resolution and corporate restructuring in the main paper also. So you can do it twice. So here in this chapter, you have only the basics, what is required. So the word meanings, the meanings of certain terms, and the most important thing is who is a debtor, who is a creditor, who is a financial debtor, who is a financial creditor, who is a financial, all those things are the ones, and who is an operational debtor, who is an operational creditor. And the most important thing is the sequence where the debt will be repaid. Who will receive the money first? That is what is the thing what we are going to be studying in this chapter. So you can actually score full marks. English is not the problem here. Here the term and the meaning of the definition is, meaning of the term is more important than the English part of it. So what are the things we are going to be looking into this? One is the CIRP. If you look at it, it is C, corporate insolvency, I, resolution, R, and P, process. So CIRP, corporate insolvency resolution process. Then you have liquidation. Then you have the meaning of a resolution professional. Who is a resolution professional? We call them the RP. And who is an insolvency professional, whom we call as the IP. And what is the winding up process. So these are the things what we will be going through. This is all the concepts what we have to understand. And the various acts or frameworks, what we are going to see here is the Insolvency Bankruptcy Code of 2016 or the IBC 2016. Then the concept of CIRP, that is Corporate Insolvency Resolution Process. So corporate is company's problem. So insolvency, we have discussed this. Resolution is to resolve or the solve, and process is the sequence of activities. So solving of the or giving solutions to insolvency problems of companies, that is what is a CIRP. Then Insolvency and Bankruptcy Board of India. So this is the board which regulates the IBC and also deals with the code of conduct, etc. for the IP and the RP who are there. Then what is voluntary liquidation? Earlier, this used to be treated under the Companies Act. Now it has been moved into the IBC itself. So we had voluntary liquidation, which we used to deal in Companies Act itself. Now it has come back here. And then you have the companies rules relating to winding up of companies. Here you will not be dealing with what is winding up, what is the process and all those things. Only a rule or two relating to the closure of the company. That is all what we are going to be speaking here. And all the regulatory frameworks, generally you have the processes which are involved. So coming to the word insolvency and bankruptcy. So they are used interchangeably. We have discussed this, but there is a marked distinction between the two terms. Insolvency denotes a state where the debts are not sufficient or the assets are insufficient to pay the debts or his general inability to pay the debt. So in restricted terms, in the sense it is to express inability of the party to pay the debts and as they become in the ordinary course of business. But bankruptcy denotes a legal status of a person or entity who cannot repay the debts to creditors. So legal status means it is not I or me or you telling that I cannot pay the debts. It is a court which says that leave this person alone, he cannot pay the debts. It is a stamp which is given for inability to pay the debts. So this is the final thing. So a bankruptcy process begins with the filing of petition in the court before an authority for this purpose. And it is a stamp which is given by the court. Okay, so this is the final one. Therefore, insolvency is inability to pay the debts. Bankruptcy is a declaration of the insolvency in accordance with the law of the land. It is the final stamp what you will be getting. So after insolvency, you can recover and become solvent, but after bankruptcy, there is no way of coming out of insolvency. And also insolvency is used for both organizations as well as corporates as well as individuals. And if it is not dealt with, it leads to bankruptcy in case of individuals and liquidation in case of corporates. So the term bankruptcy, because we have had situations, if you look at it, because this again was an argument what I have had with professionals. They are of an opinion that bankruptcy is only for individuals and not for companies. Do you agree with it? Do you agree with that statement?
No, ma'am.
No, it can be with the companies also.
Can be with the companies also.
Yeah, we have heard, right, about certain companies which have filed for bankruptcy.
Yeah.
Yes.
Especially Jet Airways, we have seen that.
Yes, ma'am.
Not only the person, but the company itself has gone in for bankruptcy. So once you have become bankrupt, I think that is the final stage. You go for closure. So closure and bankruptcy, inability to pay back the debts and liquidation. So
even the Kingfisher, the airlines also, it become the
bankrupt, right? Yes, correct. So I feel that it's both for individuals, and this was my contention. But many of them argued. They even brought this study material also. Some of them, like, Institute only is telling that it is for it's not for companies, and thing. It was in that professional study material what they had mentioned. So, but then we had this newspapers and all which said that they are filed for bankruptcy and things. So that way we were able to quash, but both the parties were not convinced about each other's statements. So here, again, there is one contentious line here. If you read this, bankruptcy in case of individuals and liquidation in case of corporates. Liquidation is closure of the company. Bankruptcy is a legal status where it is unable to pay the debts. The court saying that don't trouble them. So liquidation can be voluntary also. So how can you say that liquidation and bankruptcy are one and the same? What do you say?
It's a different,
right? So even this statement, what they have made, do you agree with it? I don't think it is a right statement to be making here. What do you say? It's an open thing. Just asking. If you read it,
bankruptcy can happen with individuals and company. Liquidation will happen in companies only.
In companies only. Can you equate the word bankruptcy and liquidation?
Maybe not.
Liquidation is converting all your assets into cash. Correct. If you have the meaning of
both the words are
liquidation. Bankruptcy, just 2 lines before they have explained that it is inability to pay the debts, legal term.
Basically, the company does not have any funds to do that. The classic example can be in the case of this is the
correct. Absolutely.
They that they don't have money to pay.
Correct. Correct. How can you say the liquidation process will be similar to a bankruptcy in individual?
It cannot be.
It cannot be. Bankruptcy, liquidation are two different things altogether. Correct, right? So again, see, this is where we get lost with all the statements made in the act or made in the study material. Just mark it and keep it in check. Okay, so because these two terms cannot be the same.
From this statement itself, these two words are contradictory to each other.
Correct. See, here only it is saying it means closure or winding up of a corporation. It is a legal process and it need not be because it is unable to pay the debts. Correct. So when you do the liquidation, you do not have the money, then you apply for insolvency. First you liquidate, then you apply for insolvency. Or when you are unable to pay the debts, you apply for insolvency and then that person liquidates. But bankruptcy is the final process. You cannot start liquidation after filing for bankruptcy. You're getting the sequence, right? So here you pay the money, you purchase the car, and then you go for insurance. That is the sequence, right? You pay the money, purchase the insurance, then you go for, then you take the car. Will that be okay? No. So here, that is what they are saying. Bankruptcy is the last step. So you cannot go and do the liquidation after bankruptcy. Okay, so basically the meaning, that's why I was very particular about understanding the terms so that we are able to pass certain judgments upon ourselves also. Okay, so literal sense, closure with regard to winding up of the incorporated things, that is companies. Incorporated organizations are companies. Unincorporated organizations are your sole proprietor, partnership firm with HUF, all these are unincorporated organizations. Now coming to IBC, so this bill, etc., I will not go into the theory of this one. IBC was passed in order to solve the problem relating to the winding up, closure, insolvency, strike off, or inability of the business to carry on the activities, all those things. Earlier, we used to go for all these matters to the court, and the court or the tribunal was burdened. Tribunal even now it's burdened. So they did not, they used to do it under the Companies Act. Companies Act had 600 plus sections. And so the time given for closures was very less. People were like, you, even with bank account, how many of us actually go and close a bank account, even if it's dormant? We say, just leave it, it will keep there on its own. What will happen? They will charge hardly 10 rupees. We keep the minimum balance and let it be there. So we are, I'll not say lazy, but we are not so conscious to go ahead and close that bank account on our own. So the same way, this was what was with regard to the closure of companies. What will happen? No charges, no operations, let it be there. One more thing will be there, not an issue. So, but your books and registers had lot of those numbers and items. So there was no way that you could close anything from the Companies Act, from the ROC point of view. The registers were huge, because as long as that company is still in existence, it is not closed. You have to keep that name and all the details of the companies there. So this became a big problem. So that is the reason they came up with this other act called as the IBBI came up with this act called IBC, that is Insolvency and Bankruptcy Code, in which you are going to take up matters relating to insolvency and bankruptcy, closure, winding up, liquidation, dissolution, then also with regard to the strike off and dormant companies also to some extent, though they are mainly dealt in the Companies Act. So you have those, one of the reasons to go in with a closure under the IBC. So the matters were dealt under the IBC. So you had separate people who were authorized to be taking care of all the matters which are coming under your IBBI, okay, or the IBC. So any person who is aggrieved of the activities of any company and where the company has not been able to pay, a creditor has not been paid, okay, by the company. So in such cases, that person, whether he's an individual or a company, can make an appeal to the NCLT and file a case against that company that this company has not paid me back the money. In case any individual has been aggrieved, like we have recently, they have included home buyers. So what is happening in, I'm not sure any of you staying in apartments, or have you been a part of the purchase of any apartments? Here, anyone staying in apartments?
Yes, ma'am. I was into a part when my younger mama bought a flat. I was there.
Okay. Oh, great. Anyone else? Apartments? Any apartment in and around any place?
Yes, ma'am. I stay in apartment.
You stay in apartment. Oh, great. Super. So what is the main thing with regard to apartments is there is this builders, they will construct these apartments and then they have to give you an occupancy certificate. So that is the final thing what they will give, that it is fit to be occupied, and then you take the key and you want to do the woodwork, or you have already got the woodwork done, whatever it is, you start staying in that particular apartment. There are this Jane lifts or something, that is one of the apartments, and then there is one more, 2-3 main builders in Bangalore. So what has happened is these people, they have charged 2 crores or something for giving these apartments, apartment buildings in different phases. They construct in A, B, C, D phases, right? So they have charged these people, and these home buyers, I think around 50 apartments were in this phase. I think C or D, something like that. So they have taken about 90% of the money from that, of that 2 crores was the charge what they were doing for each of the building, and 90% of the money has been taken. And this construction they had to give without woodwork. But the construction, because of COVID and whatever may be the reasons, could not be done. So the construction is in a very backward stage. They have not even fixed the frame for windows, and only the brick wall has been put. No plastering has been done. Okay, and 90% of the amount has been paid. They are asking the buyers to pay 10 more percent, whatever is remaining, if they want the house to be constructed. So this was around 1 year back when the COVID and all stopped. So these buyers said, okay, fine, and they paid the 10% also what was remaining. And now the frame of the windows have been put, but the glass etc of the windows not put. Plastering has been done in the on the outside, and inside roof etc plastering is still yet to be completed. The electrical work not done, and all the frames etc whatever they have put, they have only put the main frame, and the windows etc not fitted. So they kept everything in these apartments, around 45 houses. In that, they have kept it like that and handed over the keys to the builder, to the owners, saying that you want to take it, you take. We are not doing anything. So if you are such a owner, what will be your stake? You paid so much money. The builder is not ready to go ahead with by doing any more.
Complaint has to be raised, ma'am, against the builder.
Against the builder, and cost also is there, right?
Yes.
It's not very cheap. You have spent 2 crores, and to finish, the builder is not ready to go ahead. He says, I have no workers. You want to do, you cannot stay in those houses because no electricity, nothing. They have just fixed one main thing, and you have to get the wiring and all those things done yourself. Fittings has to be done by yourself. You cannot go and stay there in those houses. Another 20 to 30 lakhs has to be invested to do the finishing of those houses. Okay, so at this stage, the builder,
a complaint has to be filed against the a builder actually.
Actually, yes. So where does it go? As how do you file it? Under what category are you filing? Consumer court?
In the Supreme Court actually.
No, we can't go straight away to the Supreme Court. No, they'll say go up and fight in
Consumer court itself only, ma'am.
So what is there is recently they have opened this window for home buyers specifically, because in many places these people are being treated as the creditors, owners who have been cheated by the real estate ones. So they are treating this, they are giving this case under the IBC. Okay, where the home buyers individually or collectively, individual ones also can be taking care of it. They can sue the company. Here we have Jane Heights. So that is one of the companies. So I'm just giving that example because they have done that and the case has been filed with the IBC. You can keep looking into the Jane Heights case. You will get to know what all they have done. Okay, so in case any of you are staying or any of your friends or relatives are planning to purchase, please read the situation once before you purchase those things from Jane Heights. Okay, so this has been filed from out of the 50, 40 of them, 30 of them have filed a case together, and the remaining 20 paid the money and they said, we don't want to get into the litigation and everything. So we will go ahead. So what is the contention of these 30 ones are? We want the house to be constructed or completed, or ask that home buyer, who ask that Jane Heights to pay us back the money. Why should we spend extra money from our pocket? The value of the house is 2 crores. So if the remaining work is going to be 30 lakhs, let this Jane Heights pay us back 30 lakhs. We'll get it done somewhere else. I don't want to pay 30 lakhs from my pocket. Okay, that is one thing. Then second, the cost of litigation, etc. has to be borne by Jane Heights, because if they have done the work, I would not have filed a case against them. I don't have to spend the money on by my own if the Jane Heights had done their work on their own. So the cost of the litigation plus the cost of the work, that is what is the expectation of these home buyers. So they are filing a suit here, and the main intention of the IBC is to make sure that anything, any complaint, whatever is there, is filed and solved in the fastest pace. Unlike any court which may take years and years, insolvency and bankruptcy code has the authority to finish the decisions at the earliest. So they have a speed track here, what is there. So this code, IBC code, has overriding effects on all other enactments, whatever may be the rules under the Companies Act or under the FEMA or anything. This rule has the overriding effect on all the other enactments. And the question was brought in this case, which was it in Innovative Industries Limited, but versus ICICI Bank. Very important case law. You may get a question relating to the case law, what is there, and they may ask you to write an answer. What is the important thing relating to the giving examples of the relevant case laws? Speak whether the what is the effect of IBC as compared to the other enactments. Something like that. So this is the one, what is there, including Income Tax Act or any other act for that matter. Okay, so IBC shall prevail over any kind of act. So this has got the overriding effect. So what are the provisions of the code which shall apply to what? So first is any company incorporated in the Companies Act 2013 or any other previous act, any other company gone by special act for the time being in force, any LLP incorporated under the LLP Act of 2008, then any other body incorporated under any law for the time being in force, as the central government may specify, personal guarantors to corporate guarantors, both are permitted. Our corporate debtors, every single person is covered under the IBC, individuals or otherwise. Partnership firm and proprietorship firms. So whether it is sole proprietor or whether it's partnership will all be there. And individuals other than those referred in E. So other than guarantors or corporate debtors, every other individuals will be coming under this category. So there are three consequences with regard to the IBC. One is insolvency, one is liquidation, voluntary liquidation, and your bankruptcy. Okay, so these are the four things which are there, which will be taken care of with regard to the structure of the IBC. So do you have to remember the structure? Just read through it. They will not ask you what is the structure, but just for information's sake, you go through the one. So part 1 deals with introduction and application and definitions. Part 2 deals with insolvency, resolution and liquidation for corporate persons. Then part 3 lays down the procedure for insolvency and bankruptcy of firms. And part 4 talks about the provisions for regulation of agencies, information utilities, insolvency professionals, etc. And miscellaneous provisions or matters coming under part 5. So this is all coming under your 12th schedule, which is listed under the 29A of the code. So the salient features of the IBC. So you have the IBBI, which is the board which is used for creating the IBC. Then apart from that, you have the adjudicating authorities who are in charge of passing the judgments. Then you have the insolvency professionals. So adjudicating authorities is like a judge of the court. Insolvency professionals are like advocates who are fighting for your rights. Insolvency professional agencies are like the law firms which are taking up all the matters relating to insolvency. And information utilities are all the, you have all the sources from data sources, libraries, etc., where you are getting the information, records, whatever is there, that comes under your insolvency information utilities. So these are the 5 pillars of, if we can say, of the code, which is there with our thing. So insolvency professionals are the ones who control the assets of the debtor during the IBC, insolvency resolution process. So insolvency matters are taken care of these professionals who are registered as insolvency professionals with the IBC. So they assist in the insolvency proceedings as been envisaged in the code. And there are two tribunals to adjudicate the insolvency professional cases. So one is the companies and the other one is the LLPs. The adjudication authorities are the NCLT, that is National Company Law Tribunal, and in case you are not satisfied by this, you will go to the NCLAT. Apart from that, you also have the cases relating to individuals and partners which were handled by debts recovery tribunals or the DRTs. Now all the cases have been instituted with the insolvency professionals. Insolvency professionals will be taken up under the NCLT as the case may be. And in case you are not happy with the decision of NCLT, you can go for appeal with the NCLAT, and in case you are still not happy with the thing, you can go to the Supreme Court. Appeals from DRT goes to DRAT, and from there it goes to the Supreme Court. So these are the process or the way in which it goes. So NCLT, I can give you the example again of Cyrus Mistry. First, it was applied to NCLT. Decision of NCLT was not accepted by Cyrus Mistry, so he filed a case at NCLAT. NCLAT's decision was in favor of Mr. Cyrus Mistry. When Ratan Tata was not happy with the decision of Cyrus Mistry, decision of the NCLAT, so he has dragged the matter to the Supreme Court. They have appealed to the Supreme Court against the decision given by the NCLAT. Okay, so this is the way in which it is taken. So corporate persons resolution process. Yes, please.
And Tata company got victory in the Supreme Court actually.
Yes. Oh, great. Thank you. So Cyrus, see, for Tata, both are bye-byes. He said bye-bye to the case. He said bye-bye to Cyrus Mistry also. Actually, it was quite interesting. The worst sufferer in this case was the company secretary. No violation, nothing. The two of fought and the ant got burnt. That is how it is. Yeah. The case is still going on with the disciplinary committee. So be very careful. Yes. So resolution process. So here, what happens? There are two stages which are independent stages. First, in the process of IRP, that is insolvency resolution process, creditors, that is the persons who have lent the money, assess the viability of the debtor's business and options for rescue and revival. So the moment I give you, so you have given me, like Narendra has given, Sidharth money. Okay, so Nagendra has given 1 crore rupees to Sidharth, and Sidharth was having a very good business and everything. So, but now Sidharth has having a loss, and he says, I am unable to pay your 1 crore. So what does the first thing you hear that, oh, you're not able to pay me money back, so I will take you to the court. You don't drag him to the court as soon as you hear, because it's an expense for you. You are looking at how to recover that 1 crore. Even if I don't get interest, it's okay, but I should get back my money. If I take him to the court, I will have to spend money for fighting the case also. And I may recover that 1 crore, or I may have to lose my 1 crore fully. So what you do as a creditor, Nagendra will make sure he will try to analyze the business of Sidharth to ensure that how good it is possible for Sidharth to repay his money. He will give him ideas. Okay, why don't you sell this part of the asset so that you can recover the money, or whatever may be the way in which the business has to be done. So that is my first step as a insolvency resolution process. And then if that thing fails, then you go and apply to the NCLT that this person is unable to pay the debts. and liquidation in case the IPR process fails. So here IRP process fails, resolution process fails. The next thing is liquidate the assets, sell the assets and pay back the creditors. There are two kinds of creditors who are there. One is called as the financial creditor who has given you the loan. Operational creditors are the second type of creditors whom you owe money because they have supplied you the goods. All the time, the financial creditors consider themselves to be higher than the than the operational creditors, because they feel, you know, they are like bankers. They feel bank is bigger than the supplier, that kind of an thing they have it. So they feel that financial creditors should always be ranked higher than the operational creditors. Why so? Even the courts look at it in that way. When you have the what we call as the way in which you have to be repaid, it is called as the waterfall arrangement. Waterfall, you see, from the highest to the lowest. It falls, joke falls and all. They fall from the high mountain to the lowest one. So even the debts has to be paid in an order, which is called as waterfall arrangement under section 53. Very important section of the IBC. We will study this. Under this, first, what has to be repaid is the employees of the company. They have to be paid their salaries. You cannot leave their salaries because they have been working with you. Then the bonus, if any, which has to be paid to the employees, which has not been paid for too many years, that will be repaid. Then the next one is all the government payment, whatever is required to be paid, like taxes, bills, any of it, what is there for the government dues, what is required to be paid. After that, you have to pay the liquidator's remuneration, because the resolution person's remuneration has to be paid. Then next one, what comes is your secured financial creditors, then secured operational creditors. So you are ranked at this level before the operational creditors. So if the money gets over before the operational creditors are paid, then operational creditors have no hold at all. The first ones, why so also? Because operational creditors are mostly suppliers of goods. You don't have to supply the goods in case you have not received the money. You can take back your goods. So you have some hold on the company. You have some hold on the debtor. That's why operational creditors are ranked below financial creditors because of this reason. You need not supply the goods. That is why they have the hold there. So coming to the thing, a financial creditor for a defaulted financial debt or an operational creditor for unpaid operational debt can initiate, that means can file a case against the company that is a corporate debtor for defaulting the payment with the NCLT. So here we have a chart which talks about the applicability of the matters, etc. And this is wide notification. The threshold, what was there was all matters relating to IBC shall apply. IBC code shall apply to all the matters relating to insolvency and bankruptcy and liquidation of corporate debtors, where minimum amount of default is 1 crore. And the threshold of 1 crore was specified by notification of 24th March 2020. Prior to this, the amount was only 1 lakh. So if you had any 1 lakh, you could go to 1 lakh default, you would go to the IBC. Now they have increased it up to 1 crore. It will not go to the under the IBC. It will still be under the NCLT. You have to go through the consumer code there. This is the flow of the sections, what is required for your IBC. And now coming to the important definitions which are there with relation to our act. What is adjudicating authority? So basically the authority which is having the power to undertake it. Then who is a corporate applicant? Corporate applicant is a corporate debtor, that is a company, or a member or a partner of the corporate debtor. Member or partner, in case it is a corporate debtor, maybe a company or a LLP. Member or a partner of the corporate debtor. Member is a shareholder or a partner in case of a LLP, not a designated partner or the director, but a simple partner of the corporate debtor of, that is of the LLP, who is authorized to make an application for the same. Then individual who is in charge of managing the operations of the corporate debtors, that is the manager, or any person who has the control and supervision, the CFO of the corporate debtor. So corporate debtors means any corporate person, that is a company who owes debt to any person. Okay, so this is coming under this. Then corporate person, we have just seen this. Any person with whether it is with limited liability, partnership, or any company, whatever is there. Corporate guarantor means any person who has got the surety guarantee, whatever is there, who is giving the guarantee. Default, non-payment of the debt when it is asked for. Financial creditor, this definition has come. Any person to whom a financial debt is owed. So financial debt, what is the money, what is borrowed along with interest, money raised by acceptance of credit facility, purchase facility, issue of bonds, etc. Any other liability, lease, hire purchase, receivables, notes discounted. So basically from any financial institution where money is involved, you have borrowed the money from bank or financial institution, that comes under your financial debt, whether it is from individuals or from banks or financial institutions, it comes under your financial debts. Then any derivative transactions entered into in connection with the fluctuations, etc. So trading also comes under your financial debt. Indemnity obligation, where you have given guarantee, bond, etc., that comes under your financial debt. And any amount or any liability comes under your financial debt. So in case any definition comes, what is financial debt? Okay, so at that time there are about, it may come for 5 marks. So out of the 6, 7, 8 points or 10 points, what is there? If you write around 6 points, you will be getting full marks. Okay, but the points should not be repeated, and it is like the point H. Okay, any counter indemnity obligation in respect of guarantee, 1 point. Second point, any counter indemnity or obligation in respect of indemnity, second point. That will not fetch you marks, it will give you only 1 mark. So it has to be complete point, whatever has been mentioned as 1 point. However, it is mentioned in the study material. Okay, so that is how you will be counting the points also. This whole thing, if I split into 4 points, I'll not get 4 marks. This will only fetch me 1 mark, this much. Okay, so that is the way in which your valuation takes place. Insolvency professional enrolled under 206 of the insolvency agency. Then agency which is carrying on the functions of an agency. This again might come as a question. Insolvency resolution process costs. Any amount of interim finance, whatever money charged in between to make payment for the professional charges or otherwise of insolvency actions. So that comes under your insolvency resolution process cost. Fees payable to the person acting as RP, costs recovered for running the business or corporate debtor, costs incurred at the expense of government to facilitate the resolution process, and any other cost as may be specified by the board. So all these things are coming under this. Liquidation commencement date, the date on which the proceedings of liquidation commence in accordance with section 39 or in section 59 as the case may be. So then the cost means any cost incurred by the liquidator during the liquidation, subject to the specifications or the regulations as may be specified. Any insolvency professional appointed as liquidator according to the provisions of the Act is a liquidator. Resolution professional, any insolvency professional appointed to conduct the CIRP, includes an interim resolution professional. Interim is for the time being I have been appointed. Later on, if you are having the free time, you can continue to work. It's like a substitute class teacher. So somebody is not there, so you are working as a substitute class teacher. You may be given a permanent job. You can continue as the regular class teacher, or when the regular class teacher is coming back, you may be asked to step down. So that is what is your thing. Resolution process. Again, we are discussing the same thing. So the first one is the financial creditor. So this is under section 7 of the code, IBC code. So what is the process? First, the financial creditor. He has paid the money. Like I said, Nagendra has given the money to Sidharth. So he decides that Sidharth has not paid him back the money. So he will initiate the process. He has asked him to pay the money. He has advised him, whatever it is, there is no resolution for that particular action at all. There is no way in which he's getting. So he initiates action under the IBC by applying to the adjudicating authority, that is NCLT, against the corporate debtor, that is against Sidharth, that please do the process of initiation of getting me back my money. So the financial debt, whatever is owed, in whichever way it is owned by Sidharth, will have to be given back to the financial creditor with interest, if any. So then the next one is, along with the application, record of default will also be given. So I had given the money on this day. He was supposed to pay the interest on this day. This was how the repayment was planned. As of now, he has repaid, say, 10 lakhs, and the remaining statement from the bank, all the details relating to the default creditor and the name of the resolution professional or the IRP who is appointed will have to be taken, and the financial creditor with all the documents will, any other information, whatever is required, will be filed with the adjudicating authority. Now the AA, that is NCLT, within 14 days, 1/4 date of the receipt of the application, within 14 days of the receipt of the application, will ascertain whether the default is there or not, and then ask in case of existence of default, he will give the writing, he will issue a statement to the defaulting organization. In our case, we have Sidharth here. So if there is a default has occurred, okay, he will give in writing that why the default has occurred. In case it has not occurred, he will tell the person, that is financial creditor, that there has been no default. If he is not satisfied with the case, then it is incomplete or anything. Disciplinary action may be taken against a financial creditor himself for bringing up the wrongful initiation. So it also depends on whatever it is. So before rejecting the application, he shall give the notice to the applicant to set right his application within 7 days of the rejection. In case like here in our case, we have Nagendra, who has been rejected the application, that he has not filled it properly or it is not complete. So he will be within 7 days asked to complete the application and submit it again. If he fails to do it within 7 days, his application is treated as rejected, and he will, in case he wants to initiate another process, it has to be afresh. Okay, so in case of CIRP, so that is corporate insolvency resolution, it shall commence from the date of application. So once it is accepted from the the date what is mentioned on our application, it's just like our share transfer, it is taken up from that particular date. So adjudication shall commence, adjudicating authority shall communicate the order to the financial creditor and also the corporate debtor within 7 days of the admission or rejection of the thing. Okay. So here we have the initiation of the CIRP of the operational creditor. Same thing, same rules with the operational creditor. Default is there or not, you check. Then within a period of 10 days of the receipt of demand of notice, it will be mentioned whether it in the prescribed form is going to operational creditor debtor is going to be giving the details within 10 days of the notice that such and such a thing has happened. So in case there is an existence of a dispute or pendency of a suit or arbitration proceedings, that will be taken care of. And any unpaid operational debt, if there is any, by sending an attested copy of the electronic transfer of the unpaid debt, you will bring it to the notice of the operational creditor, attested copy of the encash check, if any, whatever is there. So what happens is, who is an operational creditor? I said he is a supplier. I have supplied goods to, say, Sanath here, and Sanath has to pay me the money. So now I am an operational creditor. Sanath has, I have filed a case against him at the NCLT saying that I have supplied the goods worth 50 lakhs. He has not paid me the money. These are the details. I supplied the goods in the month of January. He was to pay every money, all the money by the end of July. Now it is September, finished September, but he has not even paid me 10% of the value. And I will file this case against him. Now Sanath will get a notice from the NCLT adjudicating authority as to why the amount has not been paid, why there is a default. Now Sanath, if he has given any checks which I have encashed for the goods, because operations keep happening. I have supplied goods of 50 lakhs. He might have given me a check of 10 lakhs for the previous one. Whatever it is, whatever payments, whichever he has made to me, he will give proof of all of it to the adjudicating authority. All the checks encashed, all the payments made, all the other things, e-transfers, if any, whichever has been made, all the details of it, if any, will be given to the adjudicating authority within 10 days. When the adjudicating authority looks into both the matters, like if he has got the proof, he will give. Otherwise, he will keep quiet. He has no proof, and my claim will be more than whatever. So whosoever claim is correct, so adjudicating authority will finalize on that. If it comes to the notice of the adjudicating authority that the demand, whatever has been made by the operational debt creditor is right, then he will send a notice to the debtor that the money has not been paid. In case the operational creditor has falsely filed a complaint against the debtor, then he will reject the claim. So within the expiry of 10 days, if the notice or demand payment, whatever he did not receive payment from the operational debtor, notice of the dispute will be made to the adjudicating authority for initiating the corporate resolution process. So the operational creditor, along with other application, shall send all the demand, etc., invoice, whatever is there. These are all the payments. Affidavit to the extent that I have supplied so much of goods and the payment has not been received. Copy of the certificate from the financial institutions, so banks, etc., which is giving you a NOC that the payment has not been received, and the record of utility or information utility that no payment or unpaid debt was available, if any, was received by the company, received by the operational debtor, and proof that no payment or any unpaid debt has been received by the corporate debtor here. Any other proof that the payment has been received. So when this is there, the corporate debtor itself can initiate the CIRP. Okay. So if the corporate debtor feels that I am not in a position to pay anybody, okay, now Sidharth himself can initiate a proceeding against himself, saying that I don't have money. I had borrowed 1 crore from him. I had taken supply of goods from Sanath, but I don't know where to pay the money. So where the corporate debtor has committed and he's been unable to pay the debts to both operational debtor or financial creditor, or operational creditor, and such times he can initiate the process himself. So he will produce all the books of accounts and other documents which show that he is suffering a loss. No money has been paid from the bank account because there is no money in the bank account, and also the appointment, he will apply to the NCLT, please appoint an insolvency professional, interim insolvency professional or resolution professional. Whoever can be appointed, please appoint that person to handle my affairs, as I'm not in a position to handle. And also a special resolution will be passed by the company, that is the our debtor, corporate debtor, that with at least 3/4 majority, that is a special resolution, 3/4 majority, that the company is authorized to file a application to the NCLT. So in case the suspension of the initiation of the thing, in case anything contained in 7, 8, 9. So these were the things. Initiation of the corporate insolvency resolution by the by the financial creditor, that is section 7. Section 9 by the operational creditor, and section 10 by the corporate debtor himself. Okay, for no application for initiation of corporate CIRP resolution process, that is your corporate insolvency resolution process, shall be filed for any default arising on or after 25th of March for a period of 6 months, not extending for a period up to 1 year. So this was for the period of COVID, which was given. And they have initiated that please do not file. People were not in a position to operate the business and pay the money. So this is the thing where the thing was passed. Time limit for the corporate resolution thing. So they envisage that within a period of 180 days from the date of submission of the application to initiate the process. So the entire process, that is the CIRP process, has to be completed within 180 days. That is what is the thing. That is what is the statement. And the resolution professional shall file the application to the adjudicating authority to extend the period of CIRP to beyond 180 days if it is instructed at the COC meeting up with an vote of 66%. If the creditors of the company are of the opinion that 180 days is not sufficient, then at the COC meeting, that is Committee of Creditors, at their meeting with 66% voting, if these creditors are of a view that extension has to be given, so the resolution professional will conduct a COC meeting and will get the approval of the creditors with 66% approving the extension, and he will file this with the adjudicating authority and get an extension beyond 180 days. If the adjudicating authority is satisfied with the matter, so this might come as a question, section 12 is important. If the adjudicating authority is satisfied with the matter of the corporate insolvency resolution, it shall be completed within 120 days. It may order an extension beyond 180 days, but the maximum thing will not be exceeding 90 days. So 180 plus 90 is the maximum days it can give the time period. So 180 further period as it thinks fit, but not exceeding 90 days. So 180 plus 90 is the maximum time period within which the CIRP should be finished. The process should be finished. That is the adjudicating authorities thing. So basically, the corporate insolvency process should mandatorily be concluded within 330 days of the commencement of the CIRP process. So this is under section 12. And the time taken for the legal proceedings is whatever. The withdrawal of the application This is also important here. 12A, a debtor can, if any way he can make good the default, the adjudicating authority may allow the withdrawal of the application made under 7, 9 or 10. 7 is by the creditors, that is financial creditors, 9 is by the operational creditors, and 10 is by the corporate debtors themselves. If they have made any application for the adjudicating authority for the CIRP, under section 12A, if the adjudicating authority is of the opinion that so they should be given a chance to make good their default, they can allow these people to withdraw their application. So this is with regard to it. And moratorium, on the commencement of CIRP, the adjudicating authority prohibits the following under section 14. This has come as a question 4 times. Okay, so what is the thing here? One second. Yes, this question, moratorium question, has come 4 times. So what is the moratorium which is given by the IBC under section 14? So 5 marks. Any institution of suits or continuation of the pending suits will be stopped on this corporate debtor till the time you are going on. So no suits, this will be prohibiting, an order prohibiting the continuation or anything of the suits or any pending suits or proceedings against the corporate debtor, whatever may be the thing, wherever it is held, whether it is, because we saw that IBC prevails over every other law. So no case can be continuing or can be initiated against the corporate debtor. Transferring, encumbering or alienating or disposing of by the corporate debtor any assets or any legal rights or beneficial interest. So the corporate debtor cannot transfer, sell or do away with any assets or any legal rights or beneficial interest what is available to him during the pendency of the CIRP. No action to foreclose, recover or any security interest created by the corporate debtor. So this again, he cannot do anything. Recovery of any property by any owner where such property is occupied in which is there with the corporate debtor. If he is holding on to any land or property, nobody can come and claim it back from the corporate debtor till the time CIRP is going on. However, exceptions are there. A license or permit, registration, quota, concession, clearance or similar grant or right given by the central government, state government or local authority or sectoral authority constituted for any time being in force shall not be suspended or terminated on the grounds of insolvency, subject to the condition that basically no default in payment of the current dues arising out of this has been made. So here what happens is, in case any, for example, they are getting, the corporate debtor is getting electricity grant. Okay, now it says that you cannot pay anything, you cannot recover anything, you cannot give anything to the corporate debtor during the pendency of the CIRP. But this is the grant which is given by the government. This is a thing which is given by the government to everybody. So this cannot be stopped. So anything which is coming from the government, by virtue of it coming from the government or sectoral authority or local authority, will continue irrespective of whether CIRP is going on or not. But particular cases in any court of law will be taken care of. Then supply of essential goods or services also will not be terminated, and where the interim resolution professional or the resolution professional supplies goods or anything to preserve the value. So in case the corporate debtor is supplier of fruits and vegetables. So I cannot hold on just because they say that you cannot sell any goods, you cannot transfer any assets or anything. I cannot hold on to the crops, I cannot hold on to the vegetables and all. So at such times, the the resolution professional can take a decision of selling the destroyable, the goods or whatever in order to preserve them. And this moratorium is also not applicable on the transactions which have may be notified by the central government as not applicable. Any surety or contract what is there in terms of corporate debtor. So this will have effect from the date of the order, that is from the CIRP till the end of the CIRP. Public announcement. So Code 15 makes it mandatory for the interim resolution professional to make up, this also has come as a question. These are all specific questions, 5 points, whatever is there, just put it there and you will get marks. So direct questions you have from this part, this chapter. Okay, so name and address of the corporate debtor, name of the authority, where it was incorporated, with which it was incorporated, date of submission of claims, then details of interim resolutions, professional who has been vested with the management, penalties or for false or misleading statements or claims, and date on which the CIRP shall close. So this shall be 188 days from the admission of the applications under section 7, 9 or 10. Then interim resolution professional, he has been appointed when a financial creditor or a financial debtor or an operational creditor applies to the adjudicating authority for initiation of the CIRP, a mandatory for the it is also mandatory for them to propose the name of who shall be the insolvency professional to act as IRP, that is interim resolution professional. So an operational creditor may or may not propose such name. If the authority is IRP is proposed by the applicant, A&A, that is your adjudicating authority, shall appoint such person as the IRP. And the IRP has to, once the name is requested, within 10 days, he has to take over the management of the company and the day-to-day affairs. So what are the primary duties of the IRP? Make public announcement of the CIRP, invite claims from the creditors, how much should be paid to each one of them, who's the secured creditors, unsecured creditors, secured financial creditors, say unsecured financial creditors, secured operational creditors, say unsecured operational creditors. So all types of creditors, how much has to be paid to each one of them, when it was paid, all those details from the creditors. So here for purpose of all of us, we have creditors who are at high value, and get valuation of the corporate debtor done. So what are the assets? What are the things which are there? Okay. So this is with regard to our professional. Resolution professional, new category of professional who are meeting the stipulated category to be appointed as such under the IBBI. So who can be there? So you have company, whoever has passed the insolvency and bankruptcy exam, so that is the IBC exam which is conducted by the IBBI, can be practicing as a IP, insolvency professional. So after your CS, you will have to have a practice of minimum so many years, then you have to write this exam and you will be qualified to be an IP. So this is right now taking a lot of interest amongst lot of members. So many persons are taking here with regard to it. The main thing with the resolution professional is he brings the committee of creditors and the company together. So now coming to what is a committee of creditors. Remember the committee of creditors, all the creditors together, whether they are financial creditors or operational creditors, we are bringing them under one category, that is committee of creditors. But in this also you have operational creditors who are looked down upon by the financial creditors. So the operational creditors and the financial creditors put together, the committee of creditors, not less than 66% of them should be giving their votes for the approval or extension of the dates, and not more than 51% of the financial creditor shall give a decision with regard to the appointment of the RP. Resolution plan is the main idea with which it is to be made, how the resolution of the insolvency or the thing, whatever default has happened, how it is going to be done. And this plan has to be submitted to the resolution professional along with the plans whichever are there in place with the committee of creditors. Liquidation process, again, we have seen the thing with regard to the liquidation process here. Section 12, we have discussed. Here you can just go through this chart. Liquidator, liquid estate, what is there? Now, this was a new amendment which came in 2021. There has been questions relating to PIRP, that is pre-packaged insolvency process. Like you have fast-track mergers, fast-track exits, FTE, FTM, strikeouts. So you go in with strikeoffs and all instead of going in for liquidation. So for small companies, this is also one of the things what is there, which is pre-packaged insolvency resolution process. So if I give you an example, like you go to an hospital and you say you're having a heart issue. So once, if I say that I'm having a heart issue, so the moment they do all the angiogram and all, they'll say you have to go in for stenting. So you want which package? You have a 1.5 lakh package, you have a 2 lakh package, which one you want? They already have. This will be the cost of the bed, this will be the cost of the medicine, this many times the doctor will come. If you are going for a special ward, this is what is the amount, everything. So that is a package what is given. Here also you have a pre-packaged insolvency resolution process. So if you want to go in with a specific one, you go in with a PIRP, whatever is there, PPIRP, whatever is there, you can go in for that. And if you want a one-time settlement, what is the thing you want, you can choose this. So when a corporate debtor classified as MSME under subsection 1 of section 7 of the MSME Act of Development Act of 2006 commits a minimum default of 10 lakhs, he cannot for PIRP. So here what is there is with 10 lakhs default of the money, you can go in for the pre-packaged insolvency resolution process. So when the central government can increase the minimum limit up to 1 crore. So in case which MSME cannot go in for PPIRP, here the MSME which has completed a CIRP already during the last 3 years, when preceding the initiation date, already I have tried this PPIRP and again I want to keep doing PPIRP. I cannot go ahead with the initiation process. So it is undergoing a CIRP. I'm already undergoing a resolution plan and I cannot go in with PPRP. So if the MSME is undergoing a liquidation under section 33, no, not eligible to submit a resolution plan under section 29A. So basically I have already done this. I cannot be coming under MSME again under the same one. So these are the 4 things. Otherwise, you propose the name of the resolution professional and get the name of the resolution professional approved, declaration from the majority of the directors and the corporate and the partners of the, or in case it's an LLP, by the debtors, special resolution by the 3/4 of the members of the corporate debtors, that is your company, and then approval of the financial creditors. So this is committee of creditors, at least not less than 66% of them will be giving it, and also application to initiate the process of PPIRP will start. Other order by adjudicating authority. So once this has all been done, the adjudicating authority will check into the documents. If it is of the thing, it is found, it is correct, everything is there within 7 days from the date of receipt of such notice of the adjudicating authority. In case there is any defect in the documents, the application shall be properly done by the recipient. Otherwise, if it is incomplete or something, within 14 days, it shall be within 14 days of receipt of the application, the adjudicating authority may reject it, and within 10 days, the rectification has to be done and submitted back. And the time limit, this has to be completed within 120 days from the PPIRP commencement date. Then RP should submit the approved resolution plan within 90 days of the PPI CD, that is the commencement date. If COC does not approve within 90 days, then the termination, then the RP shall submit an application for termination of the PPIRP. So there we had 180 days plus 90. Here you have 90 days within which, if the committee of creditors feel that they cannot go ahead with it, we close it.
Ma'am, what's PPICD?
Commencement date. Pre-packaged, here it is, pre-packaged insolvency commencement date.
Okay.
Resolution process, when it commenced, it is become commencement date.
Okay.
Pre-packaged one is 90 days. You can make a note there. PPIRP commencement date is 90. Within 90 days, the PPIRP has to be completed. But the other one, it has to be completed within 180 days. And the maximum within which it has to be completed is 330 days. And if the COC wants extension, if it gets an approval from, if the RP gets approval from committee of creditors with 66% majority, asking for an extension for more than 180 days in case of CIRP and more than 90 days in case of your PPIRP, you have to make an application to the thing to get the resolution plan extended. In case the COC doesn't approve within 90 days, then the PPIRP will not function. You have to go ahead and do it. The same thing, a declaration of moratorium, same way as it was done for CIRP. Here also, you will have all the moratorium with regard to any kind of suits, application cases, etc. And public announcement will also be made about the resolution professional immediately after his appointment. List of claims, etc. will be taken care of. Now, this all is the repetition with regard to PPIRP. Fast track corporate resolution process. This has again come from June 2017 for fast track completion. So here again, this was extended as PPIRP. So it has to be completed within 90 days of the completion. So in case the application has to be filed by the RP to the AA for extending the time beyond 90 days. So here the COC has to give a certificate with regard to 75% of the voting. So only then you can go in with extension. The adjudicating authority extend the duration, but not exceeding 45 days. See, if the fast track one is only for a period of 90 days, means it is half of the CIRP, fast track insolvency resolution process. So fast track CIRP is for half the period, that is 90 days. I can get an extension from the for more than 90 days. That is again, if I have more than 75% of the voting of the COC. In the COC, that is Committee of Creditors, have approved with 75% voting. I can request, that is the RP can request the adjudicating authority to give an extension. Adjudicating authority cannot give an extension beyond another 45 days. So maximum time within which he can give an extension is only 45 days. So there in CIRP, original 90 days extension he could give. Here it is all half. So this is fast track CIRP process. The rest of it is the same way in which you are doing it. Yes, please.
There you told that 75% of that method quoting is there, no, ma'am. It is all like after the 90 days or before the 90 days?
No. If I before 90 days gets over.
Okay, and after that, if it is like 76%, we
like no. 90 days
days
is the maximum time within which I have to finish the process.
Okay.
I have to resolve the problem and solve it.
Okay.
So now, if the creditors feel that we cannot do it within 90 days, before the completion of 90 days, the COC
45 days, no, ma'am?
No, COC will say we want more time to think. So they will, and this more time to think has to be given by 75% of the creditors who are there in value. Okay. So with that resolution, the RP will apply to the adjudicating authority to extend the time from 90 days to give more time up to 45 days maximum.
That what, ma'am? Plus 90 plus 45, no?
90 plus 45.
Okay,
so it has to be done before 90.
75% of the voters is approved. Like 70% we got the
approval of the creditors, committee of creditors. Got it? So it is committee of creditors, 75% before 90 days, maximum extension 45 days, 90 plus 45. So if my 90th day is getting over today on 8th, okay, I can have a meeting now of the committee of creditors and take their approval with 75% voting. Tell the AA that the committee of creditors with 75% approval are asking for an extension for 45 days. So from 8th to another 45, I can take.
Okay.
But I can't take tomorrow. Okay. So before the completion of 90th day, we have to take. Yes. So this liquidation one is there in your Companies Act also. We will, I'll just leave it for the time being. We'll just do this waterfall arrangement and then I come to this liquidation process. Very important. Waterfall, as we know, it is just a fall of water from a height. So who should be given the debts, repaid the debts first? Again, this has come 4 to 5 times. At every alternate exam, you get this section 53. What is the waterfall arrangement? Very important.
Even got in the pre-test also.
You got it? Okay.
Got it, especially got it in the pre-test also.
Okay.
When you go for the liquidation, who will pay the first? The debenture holders, the equity shareholders, and some other two.
Oh, great. So this is the stages in which it is there. So process of liquidation will have to be paid first. Then all the debts relating to workmen for the 24 months, debt owed to the secured creditors, wages unpaid owed to the employees, financial debts owed to unsecured creditors, financial dues which are ranking equally in terms of central and state governments, debts to secured creditors, any remaining debts, preference shareholders, equity shareholders. Okay, so any other contractual arrangements or recipients now will be taken into consideration. Now, important one with regard to the debts, this I don't know whether you will be getting it in your other part also. Now, what happens when there is a security? So, like for example, financial creditors, if they are secured creditors. So, okay, if they are secured financial creditors, so they are secured with regard to, say, land and building. So, this financial creditor has two choices. He will say, I am a financial creditor, I have security of land and building. You just give me the land and building. I will take it, I will recover my money and do whatever I want. The remaining, if it's excess, I will give it to you. One choice. The other thing is, he will say, I have my security as land and building. You as an RP, take it. The security of land and building, liquidate it, convert it into cash and pay me back my money. So if he opts for the second one, okay, he will be ranked higher. Okay, but if he opts for the first one, he will be ranked lowest. Why so? So what is the risk here? Now, the financial creditor, Nagendra only I am taking, he has given 1 crore to Sidharth here, land and building. The value of land and building when he gave this debt, when he gave this money to Sidharth was say 1.5 crores. But today that land and value we don't know. Now you have two choices. When you gave that 1 crore, you will now say, I will go with first option. You give me the papers, I will sell the land and building myself, and then I will recover in case any excess is there, I will pay. Okay, so when you take that land and building, if you get 1.4 crores, you are lucky. 40 lakhs you have got excess, you can give it back to the resolution professional and you have recovered whatever you had given. That is done. Very lucky. Now, if the land value has gone down, you are able to recover only 80 lakhs. What happens to that 20 lakhs? For that 20 lakhs, you will be put down as the last person just before the shareholders to be getting that particular amount. If you opt for option 1. If you go with option 2, you will say, this is the land and paper. I am a secured creditor. Please take this money. Please take this security and dispose it off and just pay me the money. You are ranked at the highest as the secured creditor and the entire 1 crore is paid to you, irrespective of how much your land and building has recovered. Even if it has recovered 50 lakhs also, your money will be paid as 1 crore. Even if it is recovering only 10, even if it is recovering 1 crore, 40 lakhs also, you will be paid 1 crore. So that gives you a sense of security. So looking at it, a financial creditor can opt for either giving the security to the company, its RP himself, or selling the security and recovering the cost there. Okay, so any doubts with this much?
Ma'am, can you explain the waterfall arrangement?
Waterfall arrangement is the method, or who should be paid what first? Who should be paid first? In what order should you repay the thing when you are closing the company? Okay, first, all the costs of liquidation should be completely paid first. Then, say for example, your entire thing is you have liquidated the amount what is in your hand is 100 crores. Cost of liquidation is 10 crores, and then debt is the workman dues is another 15 crores. All this will be there. So first, out of that 100, you will take away the cost. You will be left with 90. Then you will pay the workman's thing second. So you will be left with something. Then you will pay if there are any secured creditor. Here you will be paid. This is what it means by relinquishing his security. Now, if Nagendra had given off his thing to the RP, saying that here is the security, play whatever it is, then this amount will be taken into consideration. You will be paid at this part. But if you take the security yourself to sell the thing and recover your own money, you will go last. So if you have relinquished your right, then you will be paid at the second option. So then the wages, in case any unpaid dues or anything is there, that will be paid here. Then the financial or unsecured creditors and any other dues, whatever is there, this will be the order in which who has to be paid first, who has to be paid last. So that is the one. If you look at this chart, you will get a better idea. So last to be paid is equity shareholders. Okay. Before them, preference shareholders. Before that, any dues, unsecured dues, etc. Government dues, anything, whatever is there. Financial debts to unsecured creditors, anybody, whether it's operational or financial. Wages, in case anything is due, up to 12 months. 24 months up to wages, whatever is due. So all these things are the ones which are taken into consideration. Okay, so actually this is the end of the chapter here only. They have given notes relating to the method of conducting the meeting, etc. So you can go through. In case we have any doubts, I will take it up. Otherwise, I will leave it like this only for the time being. This is just all theory what we have. Okay. So what we will do is, I'll prepare a questionnaire kind of a thing with some small questions or something, whatever has come in your question papers from part C, and I will share it with you. We will just you can just go through the questions and identify the answers also. I will try to jumble it and give it to you. Can identify the answers and see where you are not in a position to get the topic or you're not able to understand the topic or anything, we will take it up. So in the next class, I'll see next week sometime. I want to take extra sessions. So morning's not possible, no, for you, all of you? Online class morning?
No, ma'am.
No, right? So we will try it here in the evening sometime. Okay. So in case anybody is not taking, if you can just give me that information that no class is being conducted, we will take it, because now we are almost halfway through October. I wanted to finish it by end of October at least, but it doesn't seem to be likely. So 1 or 2 Sundays probably I may take for about 3 hours or 4 hours and then try to complete the topics. Okay. Because now end of October is my deadline for me, at least. Yes.
I mean, can you take the Sunday morning? Actually, a Sunday morning session can you take?
Yeah, not this Sunday. Next Sunday onwards, I'll take. This Sunday, I'm taking the oral coaching physical class, company law. So yeah. Okay. So next Sunday, I'll take. Next Sunday, once I'll do it. So same time, is it 7:30 to 10:30, something like that? Yeah.
Yes.
So in case you want any other time, you just let me know. Next week, I will take it off. Okay.
If it's okay, you can start at 8, ma'am. 7:30 is a bit.
Okay, 8 o'clock, no problem. I have no issues. You just tell me. I keep telling that only. If you find it difficult to.
8 o'clock would be.
Yeah, sure. If you find it difficult to communicate on the group, you can send personal message also. No problem. Sometimes you may find it a little awkward. That's why even that online group also is there. SBEC, only we are there. So you can even class, extra class, no class, all those things we can share. That's an impersonal group actually. Okay. Yes. So we'll do it. Okay. Okay, guys. Thank you so much. So next week, sometime I will take the class. In case anything else, I will keep you in post. Keep you posted. Thank you.
Thank you.
Thank you.